Hi, I'm Jay from Personal Bar Prep, and this is Simplified, our video series designed to simplify complicated subjects on the California bar. Today, I want to simplify for you murder. Murder on the California bar is a complicated subject because you are expected to understand three distinct jurisdictional perspectives on murder and then to seamlessly tie them together to make a coherent essay. That's a difficult task, and in order to do it, you have to be fluent in each of the three perspectives. Now, the good news is that all three perspectives apply the same process of an actus reus, that is the act that the defendant must commit in order for there to be a crime, and the mens rea, which is the mental state. All crimes require both, and they both must occur at exactly the same time. So what I want to do today is go over the three different jurisdictional perspectives and then put them together for you in the context of an essay so you understand how they work. And we're going to start with the common law. The common law murder requirement is that murder is the unlawful killing of a human being by another with malice aforethought. The actus reus here is the unlawful killing of a human being by another. The mens rea requirement is malice aforethought. So let's break those up and see what they mean. First of all, the unlawful killing of a human being means without justification, for example, self-defense, or without an excuse. The example of that would be insanity. So if you kill somebody unlawfully, you have committed murder so long as you have the proper mental state or mens rea. And in the common law, the mens rea requirement is malice or malice aforethought. And malice means one of four things, and all four of these are equal. If they exist and the act is there, you have murder. And the common law, no murder is worse than any other murder. And so here are the four ways to show that one acted with the proper mens rea under the common law. Number one, if you can demonstrate an intent to kill. If one kills somebody with the intent to kill, they have the sufficient mens rea for murder. And if someone dies at common law, that is murder. So what does it mean to show intent? Well, the essay would have to give you some facts, and if you have facts where the defendant says, I'm going to kill you, or he's planning on killing someone and ultimately does, you have a very good argument for intent to kill. But what if they're not so blatant about it? And instead they just have somebody killed, let's say by being shot in the head or stabbed in the neck? Well, then we can infer from those facts that there's an intent to kill under something known as the deadly weapon doctrine, which says we can infer as a matter of law an intent to kill where one uses a deadly weapon in the way that makes it deadly. Why else would you shoot a gun at somebody that you knew was loaded if you didn't intend to kill them? That's a rebuttable presumption, but it is very good evidence of intent to kill. The second mens rea requirement under the common law would be an intent to cause great bodily harm. As I said, you can rebut that when you use a gun to shoot somebody, you intended to kill. But even if you didn't intend to kill, there's no question when you point a loaded gun at somebody and pull the trigger, you intend to harm them. And being shot is grievous or serious bodily harm. And if someone dies as a result, that would be sufficient mens rea for murder under the common law. And then if you act with reckless disregard for human life and someone dies, that too is sufficient for the mens rea for murder at common law. What does that look like? How about driving 100 miles an hour while drunk in a school zone where the speed limit is 20 miles an hour? If you do that and you kill somebody, you are evidencing that you don't care about others' lives, and that is reckless disregard for human life, otherwise known as depraved heart or malignant heart murder. Another example would be driving down the street with a shotgun, shooting out people's windows. You're not intending to hurt anyone, you're not intending to kill anyone, you just think it's fun shooting out windows. Well, there's a great likelihood that there will be somebody behind one of those windows and they may get shot and killed. And your conduct is evidencing reckless disregard for their life. And if you do that and someone dies, you've committed murder at common law. And then finally, we have felony murder, which is no more than a transferred intent theory that says where you have the intent to commit some kind of egregious or dangerous felony, and somebody dies as a result of your commission or attempted commission of that felony, you will be guilty of murder because we will transfer the intent to commit the underlying felony to the intent to kill. And those underlying felonies are burglary, arson, rape, robbery, kidnapping, and mayhem. Any one of those are present and someone dies, that's felony murder. And at common law, that would be murder. So that's how the common law works. There is nothing in the common law that creates any kind of degree of murder. They're all just murder. Now, the model penal code, which is the second jurisdictional perspective you need to know, is a little bit different. First of all, there are only 3 ways to find the mens rea requirement for murder, and there is no felony murder in the model penal code. Rather, you will satisfy the mens rea requirements where you have purposefully or knowingly killed another. The difference is purposely means you intend the result, knowingly means you know that what you're doing could cause death and you do it anyway. Or where you act with extreme recklessness that causes someone to die. All of those satisfy the mens rea requirement for murder under the model penal code. Now you'll notice I said earlier that there is no theory of felony murder under the model penal code. Rather, the model penal code will make a rebuttable presumption that if you've committed one of the underlying enumerated felonies and someone dies, that raises a rebuttable presumption that the defendant acted with extreme recklessness. And since extreme recklessness equals the mens rea requirement for murder under the model penal code, we have the commission of one of those enumerated felonies will then lead to a conviction for murder because it proves extreme recklessness. And again, for our purposes, those underlying or enumerated felonies are burglary, arson, rape, robbery, or kidnapping. Now suppose the bar wants to know more. They want to know, is the defendant guilty of murder, and if so, of what degree? Well, neither the model penal code nor the common law deal with degrees of murder. That's a statutory construction that most jurisdictions apply, but we don't apply the law of any one jurisdiction. And so we have a generalized approach to degrees of murder. And here's how it works. If you establish common law murder, you automatically have established second-degree murder. Because all second-degree murder is the unlawful killing of a human being by another with malice. Therefore, if you've established murder under the common law, you have murder under most jurisdictions, and that will be second-degree murder. We can aggravate it. That's the term of art we use. We aggravate it from second-degree to first-degree murder based upon several considerations. Number 1, did the defendant evidence premeditation and deliberation in the commission of this murder? Premeditation and deliberation means that there was sufficient time to think about it, roll it over in your mind in a cool, dispassionate way, and decide you're going to kill. If you do that, you got first-degree murder. Some jurisdictions also include the method of killing. For example, ambushing, or torturing someone to death, or using a bomb to blow them up and kill them, or poisoning them. By statute, all of those become first-degree murder because in essence they all evidence premeditation and deliberation. You have to think about it before you blow somebody up. You have to think about it before you poison them and decide that it's a good idea. Therefore, that would equal first-degree murder. And in most jurisdictions, felony murder is first-degree murder, and the predicate crimes that we will use again for felony murder will be burglary, arson, rape, robbery, and kidnapping, and occasionally mayhem, although you don't see it on the bar. So let's put it all together into an essay question that the bar tested on not too long ago and see how it works. And the facts went simply like this. We have a defendant who works at a grocery store. He has a history of mental illness and has been in and out of psychiatric hospitals his entire life. One day while he's working, he's stocking the shelves in a supermarket. Customer comes by and complains that he can't get past the defendant who's blocking the aisle. An argument ensues, and the victim, the customer, says, "You're crazy, you ought to be locked up." And the defendant immediately gets angry and says, "Now I'm going to kill you." And he punches the victim in the head as hard as he can. The victim falls down on the ground, hits his head, cracks his skull, and dies. And the question is very straightforward. There are 4 calls of the question. Number 1, is he guilty of first-degree murder? Number 2, is he guilty of second-degree murder? Number 3, is he guilty of voluntary manslaughter? And then finally, do any of the insanity defenses protect him? I'm not going to discuss the insanity defenses today, but I do want to discuss the murder charge. So how do we deal with whether or not the defendant is guilty of murder? All right, so number 1, we have to satisfy whether or not there is common law murder, which is defined as the unlawful killing of a human being by another with malice. Unlawful, as I said, means without justification or excuse. Here, there's no question he's not acting in self-defense because the defendant is the aggressor. So the only question as to whether there's an excuse is whether or not he is legally insane, which we're not going to get into today. All right, but we do have the killing of a human being by another, and if we determine it was unlawful, now we have the actus reus satisfied. Now, what about the mens rea? Well, the defendant said, "I'm going to kill you." That's pretty good evidence of intent to kill. On the other hand, he's in the middle of an argument. He's been severely insulted as far as he's concerned, and he does have a history of mental illness. So it is very possible that when he said, "I'm going to kill you," he didn't mean "I'm going to kill you." It was more like hyperbole, like you would say, "I could kill you for doing that." Doesn't mean you actually intend to kill. And so it's possible there is no intent to kill. But what about the fact that he hit him over the head as hard as he could? That evidence is an intent to cause great bodily harm. You don't punch somebody in the head as hard as you can if you don't intend to hurt them. So that would evidence the intent to cause great bodily harm, which satisfies the mens rea requirement for common law murder. It's also reckless disregard because if you intend to hurt somebody really bad, you really don't care about what you do to them. And so that's reckless disregard for human life. And so under the common law, this defendant has committed murder. Now the question is, can we aggravate it to first-degree murder? It's going to require premeditation and deliberation. He's in the middle of a fight. Did that give him sufficient time to think about what he was going to do and decide in a cool, dispassionate way to kill? Probably not. It looks like he had a hair-trigger temper. He lost his temper and killed this guy. It's not the kind of thing where you think about it over some period of time and decide coolly, that's what I want to do. So we don't have enough for first-degree murder, even though he said, "I'm going to kill you." Second-degree murder, well, as I said earlier, all common law murder equals second-degree murder. So he's clearly guilty of at least second-degree murder. So then the only question we have to ask is, can we mitigate it from murder to voluntary manslaughter? And the primary way we do that is by showing adequate provocation with an inadequate cooling off period. Here we know that this defendant was provoked. The only question we have to address is whether or not a reasonable person in his position would be provoked to kill. And the answer is probably not. Being insulted is not enough to make a reasonable person want to kill the person who insulted them. And so it's very unlikely that there's adequate provocation. We know there was no cooling off period because it happened immediately. Nonetheless, we do not have enough to mitigate the crime down to voluntary manslaughter. And so in that essay question, the great likelihood is that the defendant is guilty of second-degree murder. That's how we analyze a murder question. Remember, we have 3 distinct jurisdictional perspectives. We have to marry them and weave them together to explain that difference and come to a conclusion. If you have any questions or comments, leave a message in our comment below. If you liked this video, you're going to love our class. I'm Jay. This is Personal Bar Prep. Thanks for listening.